Good evening, guys. I want to thank you guys for coming tonight to our second training for our common law courts. And tonight we're going to be discussing kind of the essence of common law, where common law came from, kind of how things worked in the past, and just kind of what court is and those type of things today. So I'm going to start on page 29 of Bill Thornton's Common Law Study Guide, and this starts off with the essence of common law. So it starts off with the reader objects. So basically what I'm fixing to read to you is something that someone who objects to common law being used today, or we use the statutory courts and not common law. This is someone who is objecting to the common law, and then it's going to be Bill Thornton's response to that person. And so here's what that person who is objecting to common law, he's saying, I disagree with your position that I am subject to the common law. What exactly is the common law, and who says so? And as I am sovereign, who gets to decide that I am subject to it? So this person is saying, I'm sovereign, so why should I have to be subject to the common law? Upon the Revolution, everything from England was nullified, including the common law of England. As an explanation, that which is commonly known as international law is in reality nothing but custom and practice. So, reasonable sovereigns of equal authority and power. Hang on just a second.
How many is in here?
Upon the Revolution, everything from England was nullified, including the common law of England. As an explanation, that which is commonly known as international law is in reality nothing but custom and practice. Okay, so this was what happened from the Revolution in England. This happened in like 1066. When William the Conqueror came through, and this is when they're talking about that revolution. Reasonable sovereigns of equal authority and power do not want to go to war. So basically what this is saying is, back in England, sovereigns don't want to go to war when they have a dispute with someone. So these sovereigns are careful about how they relate to other sovereigns who are their equals. This develops into custom and practice, which when violated could result in confrontation and even war. That's where we got the excuse me that is used to repair. So when we bump into somebody or something like that, we say excuse me. Basically the saying excuse me actually comes from sovereigns trying to work out their differences, and when they feel like their rights are violated, instead of going to war with one another. There is no proper way that I can be held to some previously contrived common law that I had no participation in establishing. I had no choice as to my respect thereof or my adherence thereto. So remember, this is someone's objection to common law. Why do I have to be part of common law? And so here's the response. So the response is custom and usage since time immemorial. Immemorial means like as far back as I can remember, or even back before I can remember, is generally what is behind the definition of common law. There is no singular source of the common law as one would expect with statutes made by legislature. Having said that, consider also that law follows physical power. So let's pretend that you reset your brain almost to zero. You have no knowledge, but your natural knowledge of good and evil. You have your natural intelligence, and you have a language with which you can communicate with others. You're in your sovereign capacity accountable to no higher authority, but you acknowledge the sovereignty of others and that you may not diminish the sovereignty of others. This is how we become at peace. Well, along comes another being like you who causes you pain, for which you want fair compensation. So at this point, you have a choice. You can decide to go into immediate battle with that person. So you could go to war and go into a physical fight. Or you can round up other like beings, sovereigns like you. We suggest 12 of them, which would be a jury, and ask them to join you in the battle. If you get all of them to agree that you have a just cause, then it would be you and them against the accused. That's 13 against 1. So this is how sovereigns would do things back in the old times. They would, instead of going to war and going to battle, they would gather people up and they would go to war in a courtroom. They, not having been present at the time of the crime, being fair-minded, demand that you justify your request. You provide the rule and prove your facts. You make your presentation, and the accused makes his counter-presentation, and after both presentations, which is the trial, the jury, the 12 people, retire to conjugate over the two questions. So, what's the first question? The first question is this rule valid? If, in the opinion of the jury, your rule is not valid, then you would have what's called a jury nullification, and they would nullify that rule. Then they would refuse to join you and give a not guilty verdict. But if they, the jurors, in their independent sovereign judgment, agree with your rule, then they move on to the second question. And so the second question is, did the actions of the accused violate the rule? If, in the opinion of the jury, he did not violate the rule, then they will refuse to join you and they will give a not guilty verdict. But if they, the jury, in their independent sovereign judgment, agree that your rule or your right was violated, then they will join you with a guilty verdict. If the jury's decision is split, then the issue remains unresolved and a new trial may be needed with a new jury. If the jury's decision is unanimous, whether guilty or not guilty, the question is decided, and you now have 13 versus 1. Depending on the verdict, the 1 would either be the accuser or the accused. Now, whoever lost the case would be foolish to go into an actual physical battle against 13 opponents. Thus, through this process, we bring peace to the realm. So this is how they would do things in the past. Instead of having, in America, they say we used to, take it outside and just do a gun battle and, draw your weapon and shoot. But this is the way the sovereigns would do it because they would want to solve things amicably. So an accuser always has jurisdiction to accuse, and the accused always has jurisdiction to defend. And either one may grant jurisdiction to a jury to intervene. So they could come together and try to do one-on-one if they wanted to, or they could bring in an arbitration, which is a few, or you could do 12, depending on what you guys ask, what the accused and the accuser ask for. They can ask for a jury. That is basically the bare essence of common law. Anything more than that, what I just mentioned, is an attempt to improve on the process. However, so-called improvements often are imperfect. Although there is no singular authoritative source of common law, much has been written over the past 1,000 years. Many have come to respect the thoughts and opinions of those who have preceded them. Having respect does not mean to quit thinking. because education is the process of learning about prior conclusions. Those conclusions are a valuable guide to use to arrive at our own conclusions. So basically what this is talking about is how we go back and we look at court cases. When we go back and look at different Supreme Court cases and different cases, even in what is considered de facto, we find that there are many cases that actually uphold the common law through those cases, and we can utilize those. In true common law, there are no obligatory rules or precedents. So basically what that means is when we do common law, we can set it up just like they did in the old days and just basically have everybody come in. One gives their side, the other gives their side, the jury goes and meets. A common law court is what's called a court of record. It has unlimited jurisdiction. It's also general unlimited jurisdiction and is independent of the government. That is key right there. It is independent of the government. All external factors are at best advisory and not obligatory. And what that means is like your judges and any external factors, they can advise, but nothing is obligated. It's not obligated. A common law court, any common law court can run the way it wants to. And when it says independent of government, what that means is, for instance, in the statute courts that we have right now, your judges are part of the government. Your attorneys are part of that bar association, British Accredited Registry, part of the government. So your lawyers are part of the government, your judges are part of the government, and then your witnesses come in and they're cops. And guess what? The cops are part of the government. So basically all of the government is in this process, and we as the people or sovereign have a hard time getting a fair trial because we're supposed to be independent of the government. It's supposed to be the people that are utilizing these roles and not the government. So I'm going to move forward. The Founding Fathers understood everything that I just said. At his 1801 inaugural, Thomas Jefferson said, "Sometimes it is said that man cannot be trusted with the government of himself. Can he then be trusted with the government of others? Or have we found angels in the form of kings to govern him? Let history answer this question." And he wrote, "I know no safe depository of the ultimate powers of the society but the people themselves. And if we think them not enlightened enough to exercise their control with a wholesome discretion, the remedy is not to take it away from them, but to inform their discretion." That was a letter that was written in September 28th of 1820. So basically what he's saying there, he's like, you know, government can't be trusted, and the government of others can't be trusted. Should we look towards kings to govern us? But what he's saying is, I know of no power other than the people. The people should be the power that governs themselves. And if the people aren't knowledgeable in these areas or in common law or these things, then it is our job to inform them and to educate them, but not take common law, not to take the common law or the ability to govern away from the people, but instead we need to be educated. And that's what Thomas Jefferson wrote. The self-correcting temporary imperfections of common law were preferable to the entrenched imperfections of legislated written laws. That is why they chose, this is our Founding Fathers, that is why the Founding Fathers chose the common law as the law superior to statutes and all other forms of law. They expressed that choice through the Constitution's 7th Amendment, which essentially says that no court may second-guess or review a decision of a jury. Also notice that although the common law is outside of the Constitution authorizes the United States of America to support the common law with its judicial power, and that's in Article 3, Section 2-1. A statutory or constitutional court, whether it's an appellate or a Supreme Court, may not second-guess the judgment of a common law court of record. The Supreme Court of the United States acknowledges the common law as supreme. The judgment of a court of record whose jurisdiction is final is as conclusive on all the world as the judgment of this court would be. It is as conclusive on this court as it is on other courts. It puts an end to inquiry concerning the fact by deciding it. That was Ex parte Watkins. And so basically, Ex parte Watkins is a case that is defending that the common law court is over and the superior court of our land here, and that it is its judgment is final. All right, I'm going to stop right there for just a second. That's kind of the essence of what common law is, and then I'm going to explain what is a court. Let me come up here for just a second. Let's see, we've got a lot of more people here. So based on the essence of common law, kind of how it springs forth and how the sovereigns worked with one another and how they solved issues and resolved problems, are there any questions or comments on what we've discussed so far? And if you want to unmute yourself to speak, you can, and then just mute yourself back when you're done. Any comments or questions?
I have a question. This is Nana.
Hey, Nana.
What you were reading just a minute ago, that case that was was it Watkins?
Yes, Ex parte Watkins.
Yeah, there's a second case mentioned on that. Was that in 1973?
Let me go back.
It looks like the second case cited was 73, but it didn't have the cite on the Ex parte Watkins.
It doesn't have the date on Ex parte Watkins. It said that it's cited by, so Ex parte Watkins was cited by however you say that, Bustamante in a court case in 1973. So they actually, in 1973, somebody used it and they defended it.
That's right. Okay, thank you.
You're welcome. Any other questions, comments, concerns, discussion? All right, if there is no more, we're going to go ahead and move forward. Nana, will you mute yourself? And we'll move forward. All right, so now we're going to talk about what is a court. This article is about the substantive definition of a court. For form, legal, and dictionary definitions, see court of record. Most attorneys will tell you that a court is a forum where litigants may take problems for resolution. Others will tell you that the terms court and judge are interchangeable, but that is not true. A court is actually separate from a judge. They are not interchangeable. Then there are various dictionary definitions, but here is just the real substance of what a court is. A court is a stage upon which the sovereign conducts his show so as to satisfy the rest of the world that his decision is a good one. And basically how it would work is if anything ever came up back then, a sovereign would immediately put together a court, because the court is the stage where he gets to present himself and present the facts of his case for remedy. So the modern concept of a court is based on the old ancient English traditions. To best understand it, imagine how things were in the 12th century. The king He was the sovereign. He was on his throne by divine right. He was the source of all law. So went the theory. But the king was as vulnerable to death as anyone else. So consider this scenario. So the king, he's sitting on his throne, he's gazing out his window, and he's surveilling his kingdom, and he noticed one of the knaves, which would be a villain or a hoodlum or a good-for-nothing. He sees him. He notices one of them is stealing oranges from his favorite orange tree. No problem. He contacts his guards, and he summons them up and instructs them to incarcerate the knave for a month in the castle dungeon. There you have it. All the elements of a basic court procedure are right there. You have jurisdiction, evidence, accusation, judgment, and punishment. The king had the jurisdiction. He had personally seen the violation of his rules, the evidence. Then he rendered and executed the judgment. Theoretically, that is all that is needed for a court. As a practical matter, there is more to the story. In this case, the criminal's brother happens to be the king's chief cook. The cook takes the day off to visit the dungeon. The prisoner complains about the injustice of it all, that he meant no harm and that he didn't do it, and that the king was totally unfair. Well, Mr. Cook, he's enraged by his brother's story, and so he promises to help him out. That evening, the king dies from a slight overdose of arsenic. That's how the nobility solved problems back in those days. So if you had a problem with the king and you had a problem with one of his laws or a court case or a judgment that he made, then the family members could just go and, the cook, get the cook and take out the king. This was known as the arsenic factor. This is what led to our modern court system. The royalty of that period, so this is in the 12th century, okay? The royalty of that period realized that they were vulnerable. So they devised a trial system which would encourage others not to take it out on the king. This resulted in the second scenario. So here's the second scenario. The king is sitting on his throne, gazing out his window, surveilling his kingdom, and he notices that one of the knaves, who's a hoodlum or a rascal, is stealing oranges from his favorite orange tree. No problem. So he summons the guards and instructs them to bring the knave before the court. Papers are drawn up, and a formal accusation is published for the world to see. A future date is set, and the knave is given an opportunity to round up defensive evidence and witnesses, as well as a king-trained, tested, and licensed defense attorney. So now we have a defense attorney. On the appointed day, the king's representative publicly announces the accusations. The defendant publicly states his innocence and the reasons therefore. There's a great argument is heard from both sides, and the king renders his judgment. And he says 30 dungeon days. Attending the trial are the various court officers. You've got the judge, the counselors, the marshal, the court reporter, the court jester, the court clerk, and various courtiers who invariably attach themselves to the seat of power. Among them all is the prisoner's brother, the king's chief cook. On visiting day at the dungeon, the criminal complains on deaf ears. Brother Chief Cook says, "Sorry, bro, I was at the trial. I saw all the evidence. I saw that you had an opportunity to defend, and I saw that the judgment was according to the law. Even if the judgment was in error, the procedure was fair. There's nothing I can do for you." The king's show was a success. Because of public judicial procedure, he is guaranteed a long, arsenic-free life, even though there was no difference in the final outcome. In the first scenario, the king acted according to theory. In the second scenario, the king acted with prudent life-extending considerations. So basically, you have the king still getting his way both ways. And even though that the criminal case was heard, on both sides, it's still the king that makes the judgment. So that is basically how our courts are today, the same way. But our founding fathers saw the common law courts where the people make the decisions and not the king. So modern court procedure still adheres to the traditions of the past. You can see this in the various rules, statutes, and canons. For example, in Canon 2 of the Code of Judicial Conduct, it is well understood that a judge shall comply with the law and should act at all times in a manner that promotes public confidence in the integrity and impartiality of the judiciary. There is no specific requirement that he actually have integrity and impartiality beyond the minimum requirement by law, only that the judge should act in a manner that promotes that image. Maintaining image while protecting sovereign interests is probably the most important function of a court. The actual effectiveness of a government court in meting out justice has been questioned. And basically, spend a day in any traffic court and you will get the full flavor of how the courts protect sovereign interests as they put on a show of procedural propriety. And they just run these guys in. Will and I were just at a traffic court a couple weeks ago, and they just run these guys in and just take their money away and just run them right on through. People don't even get the ability to speak for themselves hardly. And that's the exact same thing that we have that this king was doing, where he was just given the law. So let's talk about what is a court of record. So this writer concludes from the definitions below that a court of record is a court which must meet the following criteria. So if it's a court of record or a common law court, so a common law court is a court of record, it must have a seal, it must have the power to fine or imprison for contempt, it keeps a record of the proceedings, it keeps the proceedings according to the common law and not according to statutes or codes, and the tribunal is independent of the magistrate, or the judge. So the tribunal is going to be one of two people or groups. Your tribunal is going to be your jury. That is your sovereign group, your 12-member jury. That's your tribunal. But the way that Bill Thornton teaches this stuff is that you can actually go into their courts as a sovereign and turn their court into a court of record. So as I read some of these and go through this study guide, there's teaching on how to turn their courts into a court of record because we're owed it. But the tribunal is either going to be your jury or your tribunal is going to be your sovereign, who is either the accuser or the accused. And they will be they can actually take control of a court. Your judge is not the tribunal, ever. Note that a judge is a magistrate and not the tribunal. So basically, it's saying what I said here. The tribunal is either the sovereign himself or a fully empowered jury. And the jury cannot be paid by the government as well, because it has to be independent of the government, which we read earlier. So a court in Black's Law Dictionary under international law, the person and suite of the sovereign, the place where the sovereign sojourns with his regal retinue, those who accompany a king or sovereign, wherever that may be. And so this is like, so your court is you, the sovereign. And when it says those that accompany a king or a sovereign, that can be your jurors, or that can even be your witnesses, whoever that may be. Classification. Courts may be classified and divided according to several methods, the following being the more usual. So a court of record and then courts not of record. These are key things of knowing So some of these de facto courts will say they're courts of record, but if they're not operating in that individual case as a court of record, then it's not a court of record. I'm going to go through a couple of these cases that are right here. This one is Thomas Fletcher Company and Ex parte Thistleton. So the former being those whose acts and judicial proceedings are enrolled. So the former is what's called a court of record. The court of record are those whose acts and judicial proceedings are enrolled or recorded for a perpetual memory and testimony, and which have power to fine or imprison for contempt. Error lies to their judgments, and they generally possess a seal. Courts not of record are those of inferior dignity, which have no power to fine or imprison, and in which the proceedings are not enrolled or recorded. And so that is basically kind of a classification of that. A court of record, this one is Jones versus Jones. It's got some more in here, Ex parte Gladhill. This says that a court of record is a judicial tribunal having attributes and exercising functions independently of the person of the magistrate designated generally to hold it, and proceeding according to the course of the common law, its acts and proceedings being enrolled for a perpetual memorial. So there it goes again, another case saying that a court of record, and look, it even tells you that it's independent of the magistrate. The judge is not the tribunal, and which is totally opposite of what we see in the courts that we have here. So here's number 7, California jurisprudence. This is Bancroft and Whitney, 1922. This is page 580 and 581, and this talks about courts of record. Courts of record. Courts are divided generally into courts of record and those that are not of record. A court of record is a judicial tribunal having attributes and exercising functions independently of the person designated generally to hold it. That's going to be your judge. And proceeding according to the course of the common law. In a court of record, the acts and judicial proceedings are enrolled, whereas in courts not of record, the proceedings are not enrolled. The privilege of having these enrolled memorials constitute the great leading distinction between courts of record and courts not of record. Again, this is Ex parte Thistleton. As to what are courts of common law jurisdiction within the meaning of the Federal Naturalization Act, and that's alienage and citizenship. And as far as like courts of common law jurisdiction, pretty much everything, if it's a people, so if it has to do with people, it would fall under common law land jurisdiction. If it has to do with title, real property, so real property would have to do with title, allodial title, land patents, anything that has to do with land, it would fall under that jurisdiction. So anytime we are challenging jurisdiction in these courts, they are C courts that deal with commercial business, commercial transactions, commercial entities, corporations, those types of contracts, those types of things. They can't deal with people, and they're not supposed to be able to be dealing with land. But anything that happens on the land, so, you know, if they pull you over for expired tags or whatever, that happened on the land and soil. So you can immediately pull it into the land and soil jurisdiction because it happened on land and not at sea. Let's see. Also here on this, it says under constitutional revision of 1863, so there was a revision in 1863. The district, county, and probate courts were also considered courts of record, but I know that they revised that in 1863, but probate courts and common law were never supposed to be courts of record or even attached to the common law. So I know that that has been mentioned quite a few times, that probate courts were really not supposed to be put in there. So magistrate, it's going to take a minute. It's going to talk our judges. This is the person holding official power in a government. So this is their definition of a magistrate, because it's an official power in a government, the official and highest rank in a government, chief or first magistrate, an official of class having summary, often criminal jurisdiction. These are Webster's dictionaries. An online dictionary says an official entrusted with administration of laws, person clothed with power as a public officer. This is a case that talks about what one is. A public officer belonging to the civil organization of the state and invested with powers and functions which may be either judicial, legislative, or executive, but the term is commonly used in a narrower sense, designating in England a person entrusted with the commission of peace, and in America one of the class of inferior judicial officers such as justices of the peace and police justices. This is Martin versus State. Also through Ex parte White, State versus Allen, goes back through there. The word magistrate does not necessarily imply an officer exercising any judicial functions and might very well be held to embrace notaries and commissioners of deeds. This is actually pretty interesting right here. This is Schultz versus Merchants. This is for a common law court right here. If you had to convene your own common law court and it didn't go through like ours, which is done through the state and done through, you could actually utilize a notary or a commissioner of deeds, and they can actually stand in and be a magistrate in your court. If something happened and a place doesn't have a court set up in one of the states, you can actually use a notary and use them as a justice, which is interesting. Let's see. So the California Penal Code, words and phrases. The following words have in this code the signification attached to them in this section, unless otherwise apparent from the context. So the word magistrate signifies any one of the officers mentioned in section 808. So now it's going to show you 807 and 808 of the California Penal Code. And this is the California Penal Code, but a lot of the codes for the states are real similar. So we're just using this as an example. In 807, a magistrate is defined as an officer having power to issue a warrant for the arrest of a person charged with a public offense. That was enacted in 1872. So for us, that's enacted after everything became a corporation, so it doesn't actually stick with what we've got, but this is what the code says. Person designated as magistrates. The following persons are magistrates: the judges of the Supreme Court, the judges of courts of appeal, the judges of the superior courts, the judges of municipal courts, and the judges of justice courts. And so ours are the superior courts. Black Law's Dictionary, and this is when you bring a suit. And what I learned earlier this week is they actually didn't call it like, we call it a lawsuit or a suit. They called it a suite. It's actually pronounced suite, S-U-I-T, suite. This is a witness or the followers of the plaintiff. So the followers of the king, the sovereign, the followers of him, that would be his suite, his entourage, his people that are with him. So a generic term of comprehensive signification and applies to any proceeding by one person or a person against another or others in a court of justice in which the plaintiff pursues in such court the remedy which the law affords him for the redress of an injury or the enforcement of a right, whether at law or in equity. And so when it says whether at law, that's going to be common law, or in equity, that's equity courts. So that's basically kind of giving you a generic, what is a suit. Next is a tribunal. So this is blocks Black's Law Dictionary, 4th edition. A tribunal is the seat of a judge, the place where he administers justice. The whole body of judges who compose a jurisdiction, a judicial court, the jurisdiction of which the judges exercise. Now, a tribune. In ancient Rome, a magistrate whose special function was to protect the interests of the citizens from the patricians, and it would be any defender of the people. And so the jury is your tribune. That is our tribune, is the jury. In the Merriam-Webster Online Dictionary, it gives you some different definitions of a court. The court is the residence of a sovereign or similar dignitary. Now, I know some of you are going to go, wait a minute, residence. This is not their domicile when it's talking here. The residence, so the court is the residence where they reside. So the sovereign, the court is where they reside. That's where they hold court. It can be done anywhere. If you have your sovereign on the side of the road and you have your jury and you have your stuff right there on the side of the road, you can have it hold court right there on the side of the road. Doesn't matter. Your court is where you are. A sovereign and his officials are advisors as a governing power. Number 3, an assembly of the retinue of a sovereign. An open space enclosed by a building or buildings, a space walled or marked off for playing a game, like that's a tennis or a basketball court, some sort of court, or the place where justice is administered. It's a judicial body or a meeting of the judicial body. So that's basically, it's your judicial body. And you need sovereigns for the court. Now, a minute order. A minute order is something that is issued by a judge, and this is actually not part of the record. I'm going to teach you guys what a minute order is here later, but that's actually kind of in the wrong spot. But here's the record. So, the records of a court. So, the proceedings of the courts of common law are what we call records. By every minute made by a clerk of the court for his own future guidance in making up his record, that is not a record. So your minute by minute, like, so we have minutes in a meeting. So the minute by minute of like a court and the record of the court is actually not part of the record. What's part of the record is consists of 4 things, which is right here. The common law record consists of 4 things. It consists of the process. It consists of the pleadings. It consists of the verdict and the judgment. That's your common law record. That's the record that we have to have. Now, what is the process? We do what's called due process. So due process is going to be all of your notices. That's going to be all of the notices and all the things you've given these people time. That's your process. So all of the notices that you have, all of your back and forth that you might have, it's all right there. That's your process. The pleadings. So the second part of the court is the pleadings. The pleadings are going to be when you actually have your court case. The pleadings are not when you go plead not guilty or guilty. That's not a pleading. The pleading is when you actually plead your case. This is when you do the law of the case and you actually go before the court and you give everything you've got. You present it all. That's your pleading. Then you have the verdict and the judgment. So the verdict's going to be given by the jury, and then the judgment's going to be, okay, what is there going to be of the remedy? What remedy are we going to have here? So after judgment, such errors were reviewable by what's called a writ of error. So there's your 4 parts of the process. If you have a judgment and if there were errors in the record, it can be reviewable by what's called a writ of error. Errors which occurred at the trial are not part of the common law record and could be reviewed by a motion for a new trial after the verdict and before the judgment by statute. Such errors could be reviewed after judgment by incorporating them into the record by means of what's called a bill of exception. It was therefore essential to keep clearly in mind the distinction between the matter of record and the matter of exception. So I'm going to explain what a matter of record is and the matter of exception. Basically, what this is saying is if there's any errors in the actual court record itself, there is a way to review it by a writ of error, and then another way is a bill of exception. And so you got to know which one's which. Under the ancient practice, the proceedings in a litigated case were entered upon a parchment roll. So way back then, when they did the proceedings, they wrote everything down on a parchment roll. And when this was completed, the end product became known as the common law record. It consisted of 4 parts. So here we go again. It's got the process, which included the original writ and the return of the sheriff. And for us, that's going to be our notices, by which the court acquired jurisdiction over the defendant. Then you're going to have the pleadings. So that's where you have the presentation by both parties in the prescribed order to develop an issue of law or an issue of fact, and which included a declaration and all subsequent pleadings. So your whole case, we call it what's called the law of the case. It's all going to be in that one document, and everything will be in there. It's going to be together with any demurs that you may have, which I don't know if I've covered demurs, but we will cover demurs at a later time. Then you have what's called the verdict and the judgment. These 4 elements is what forms the common law record, but it should be observed that at the point where the retrospective motions come into play, the record has not been developed beyond the stage of entering the verdict upon the roll. At this point, it should also be recalled that between the time of the pleadings, that's terminated in an issue, which joinder in issue was duly recorded on the parchment roll, and the time of the entry of the verdict was made, nothing was recorded on the parchment roll. The reason for this was between the joinder of issue and the redention of the verdict, the trial takes place, and what occurs during the trial does not appear on the face of the common law record. Thus, offers and rejection of evidence, the court's instruction of the jury, or its refusal to instruct as requested by counsel, or any misconduct connected with the trial, such as prejudicial remarks or part of the court and the like. That is, any error that occurs during the trial cannot be corrected by resort to the common law record because not apparent upon the face. Such errors were preserved only in the notes made by the presiding judge or in his memory and were reviewable. After the verdict and before the final judgment, by a motion for a new trial made before the Court en Blanc at Westminster within 4 days after the commencement of the next term following the rendition of the verdict. As each of the judges of the court had motions of similar character coming up for discussion from the trials over which they had presided, the natural inclination of each judge was to support the rulings of his brother jurists, and thus overruled the motion for a new trial. Furthermore, errors that occurred at the trial were not reviewable after judgment on writ of error, because not apparent on any of the 4 parts of the common law record. To remedy this defect, Parliament enacted Chapter 31 of the Statute of Westminster II, which provided for review of such errors through the use of what came to be known as the Bill of Exception. Okay, so basically this is telling you if you end up having errors in your court case, whether it's part of the court of record. So the court of record is only going to have your process, your pleadings, your verdict, and your judgment. So that's part of your court of record. What's not going to be on the face of the court of record is going to be the actual trial itself. The trial has its own record, but it's not going to be put in the actual court of record. It will be used as what's called the minutes, or what the clerk or the judge would kind of put together as a transcript. So there's 2 different ways that you can actually look at the court of record, which is all of the stuff, and then the actual trial itself. So you have a bill of exception that it allows you to be able to do that. That was actually changed in 1285. So, thus it appears that in 4 out of 5 retrospective motions, the court is permitted to consider only defects apparent upon the face of the part of common law record. The process, the pleadings, the verdict, and errors occurring at the trial were regarded as irrelevant and not to be considered in rendering judgment upon motions. Matters irrelevant to or outside of the record could be tested after the verdict and before the judgment only by a motion for a new trial. A distinction is made between the matter of record and the matter of exception. So, here's a distinction. The matter of record refers to those errors that are apparent on the face of the common law record and hence reviewable after the final judgment upon a writ of error. So you can use a writ of error if there is something that is an error in our records. We can use a writ of error for those. Now, a matter of exception, referring to those errors which actually occurred at the trial and were not apparent on the face of the common law record, can be reviewable after final judgment only by incorporating such errors into the record by means of a bill of exceptions. So, basically, I know I just read through a whole bunch of that, and some of you are thinking, what in the world does this have to do with what we're doing? But basically, if we have an error in any of our records, we can actually go back and have them fixed by a writ of error for the actual proceedings of the common law record, or you can do a bill of my mind just went blank. A bill of, it just left my.
Exception.
Yes, thank you. I was looking for a bill of exception. You can use the bill of exception in order to correct any errors that you have on the actual trial itself. But just so you know that if there's an error there and we need to fix an error, it can be fixed. But as far as the judgment of the case, that judgment is final. Our judgments in common law courts are final. But we can correct our errors if we have an error in there. Proceedings in courts of chancery are said not to be, strictly speaking, records, but they are so considered. Basically, this is just saying that chancery courts, some of them are considered as courts of record as well. Okay, so here's a minute. In practice, minutes. It's a memorandum of what takes place in the actual trial itself in court. It's made by the authority of the court, and from these minutes, the record is afterwards made up. So that's how we put the minute. That's how we put the record of the actual court proceeding, trial proceeding together, is from those minutes. But those minutes are actually not part of the other court of record because they're in two separate things. Tollier says that they are so called because the writing in which they were originally done was small, so like minute. So the writing was small. Instead of minute, it would be minute. That the word is derived from the Latin minuta or scriptura, in opposition to copies which were delivered to the parties, which were always written in a much larger hand. So what it's saying is that they always had the court minutes or whatever in small writing, but when they gave copies of that to the parties, like the defendant or the accuser and the accused, they always were, they had it written bigger than what they had. Minutes are not considered any part of the record. There again, it's not part of the actual common law record, but it is. We do have them. A minute book. This is a book kept by the clerk of a court in which minutes of proceedings are entered. Hang on.
This is Robin. I can't help but wonder if the minuteness of the writings was actually maybe shorthand to keep it minimal on trying to keep up with, what was said and that kind of thing instead of small print. I'm wondering if it was shorthand.
It very well may be, because even your transcribers, the transcriber or court recorders, they use that shorthand on their typewriter things that they use. I'm sorry, guys. I just almost choked to death for no reason. But Robin, you may actually be very well correct on that as far as minutes. Because that's basically how they transcribe them there too. Let's see what we have next. Next, we're going to talk about superior courts and inferior courts. But first, is there any questions, comments, concerns on what we've covered? Is on how the courts kind of work, and what their layout is, and anybody have anything? If nobody has anything, then we will continue to move forward. All right, so right now we're going to talk about superior court and inferior court. A court of record, which is what we are, that's the common law courts, we are the superior court. A court not of record is an inferior court. Inferior courts are those whose jurisdiction is limited and special, and whose proceedings are not according to the course of the common law. This is ex parte Kearney. And so pretty much all of the courts that we're used to dealing with in our counties, in our state, they are inferior courts because they have what's called limited jurisdiction or special jurisdiction. And they do not work within the common law. They are not part of the land. They are in the sea jurisdiction. And not with us. Criminal courts proceed according to statutory law. That's your statutory courts, your sea courts. Jurisdiction and procedure is defined by statute. Likewise, civil courts and admiralty courts proceed according to statutory law. Any court proceeding according to statutory law is not a court of record, which only proceeds according to the common law. It is an inferior court. The only inherent difference ordinarily recognized between superior and inferior courts is that there is a presumption in favor of the validity of the judgments of the former, which is the superior court, none in favor of those of the latter, which is your inferior court, and that a superior court may be shown not to have had power to render a particular judgment by reference to its record. That's ex parte Kearney. Note, however, that in California, superior court is the name of a particular court, but when a court acts by virtue of a special statute conferring jurisdiction in a certain class of cases, it is a court of inferior or limited jurisdiction for the time being, no matter what its ordinary status may be. So that is Heidenfeld versus Superior Court. So basically what that's saying is if a court is acting, even so it can be a what you call a court of record or a superior court, but if it's acting in even in certain cases, if it's going to be acting as an inferior court or limited jurisdiction, depending on the type of case that it has. The decisions of a superior court may only be challenged in a court of appeal. The decisions of an inferior court are subject to collateral attack. In other words, in a superior court, one may sue an inferior court directly rather than resort to appeal to an appellate court. So kind of basically this is what we're kind of in a nutshell doing, because this is a superior court coming in and suing an inferior court when they're not ruling on jurisdiction or even acknowledging us. We're basically going in and going after that, the court officials themselves. Decisions of a court of record may not be appealed. It is binding on all other courts. And this is probably one of the most important things. A court of record, that's our common law courts. When we have a decision of a court, it may not be appealed. So these superior courts, they can only be challenged in a court of appeal. But our superior courts of record, which are common law, they can't be appealed at all. Our judgments are binding, and they're binding on all other courts because all other courts are inferior to the common law courts. However, no statutory or constitutional court, whether it be an appellate or Supreme Court, can second guess the judgment of a court of record. The judgment of a court of record whose jurisdiction is final is as conclusive on all the world as the judgment of this court would be. It is as conclusive on this court as it is on other courts, and it puts an end to inquiry concerning the fact by deciding it. So there again, this is Ex parte Watkins. We've mentioned this one before, but this solidifies that the court of record is the superior judgment. Now, coming into the last piece of this, and this is Nisi Prius Court. George H. Collins wrote in Black's Law Dictionary, it defines Nisi Prius courts as: the Nisi Prius courts are such as are held for the trial of issues of fact before a jury and one presiding judge. In America, the phrase was formerly used to denote the forum, whatever may it be its statutory name, in which the cause was tried to a jury, as distinguished from the appellate court. To me, that says the Nisi Prius court is a trial court, which of course is where the facts of the case are discovered. Thornton says a Nisi Prius court is a court of no record, but a record is kept in a trial court. So these trial courts are the courts that they're trying to bring us through, because we have what's called a trial by jury. These are trial courts where you would have a jury trial, but it's not going to be of your peers. Bill Thornton replies, on the surface of it, your doubts are reasonable. I'll do my best to explain what a Nisi Prius court is. There are courts of record and courts of no record. First, the mere keeping of a record does not qualify any court to be a court of record. Black's Law Dictionary, 5th edition, contributes to the confusion by listing only 2 of the 4 requirements for a court to qualify as a court of record. If you want the full explanation, see 1215.org under Law Notes and a court of record. In California, all courts are named as courts of record. However, if an individual case, they are not operated as a court of record, then they don't qualify as such. It takes more than a name to make a court of record. Even though a court may be keeping a record, it is not considered a court of record if it does not conform to the remaining 3 requirements for a lawful court of record. Black's Law Dictionary omissions are subtle, but if you look deep enough, you can recombine the information and get the real meaning of the terms, such as Nisi and Prius. So Nisi Prius is a Latin term. Individually, the words mean this. So Prius means first. For example, Prius vistus laboribus nunc ligibus means we labored first with vices, now with laws. That's quoted from Black Law's Dictionary, 5th edition. So prius means first, and nisi means unless. This is also quoting from Black Law's Dictionary, 5th edition. It says, the word is often affixed as a kind of elliptical expression to the words rule or order or decree or judgment or confirmation to indicate that the adjudication spoken of is one which is to stand as valid and operative unless the party affected by it shall appear and show cause against it or take some other appropriate step to avoid it or procure its revocation. So, a rule of procedure in court. So, prius means first and nisi means unless, okay? So, a rule of procedure in courts is that if a party fails to object to something, so if you fail to object to something, then that means that you agree to it. A nisi procedure is a procedure to which a person has failed to object. So if you fail to object or fail to show cause, and therefore it follows that the person agrees to it, or conforming to the format in the preceding paragraph, a nisi procedure is a procedure to which a party agrees unless he objects or shows cause. A nisi prius procedure is a procedure to which a party first, so there's your prius, first agrees unless, there's your nisi, he objects. So a nisi prius court is a court which will proceed unless a party objects. The agreement to proceed is obtained from the parties first. It is a matter of right that one may demand to be tried in a court of record. Okay, that right there is our most important thing. This is a matter of right. We have the right, based on the Constitution and the Declaration of Independence and our Bill of Rights, to demand to be tried in a court of record, which is a common law court. By sheer definition, that means that the court must proceed according to the common law and not the statutory law. The only way that a court can suspend that right is by the prior agreement of the parties. For tactical reasons, the state prefers to proceed according to statutory law rather than common law. The only way it can do that is to obtain the prior agreement from the parties. That is the primary but hidden purpose of the arraignment procedure. So I want everybody to engage what I just said, because this is key right here. This is where they try to get us. We have the right to demand a court of record, a common law court, but where these courts will trick us, okay, these courts, they trick us in the arraignment process. Here's how. During the arraignment, the court offers 3 choices for pleading. You've got guilty, you've got not guilty, and you've got nolo contendere. Nolo contendere is when it's right here. It's a plea by a defendant in a criminal prosecution who accepts a guilty plea but does not admit guilt. So those are your 3 options in these arraignments: guilty, not guilty, or nolo contendere. But all 3 choices lead to the same jurisdiction, namely a statutory jurisdiction, not a common law jurisdiction. That is to say, the question to be decided is whether or not the statute was violated, not whether the common law was violated. So that's where they get us, is in these arraignments. That's where we have to not plead. If they ask you to plead guilty, not guilty, or nolo contendere, you don't plead. You are innocent. In common law, you're innocent until you're proven guilty. So you would be, I'm innocent. But this is where they tie us in and they get their jurisdiction over us there. The dictionary does not lie in its definition of a nisi prius court, but it does omit some important information, namely that it is a court that has been set up by prior agreement, assumed when the 3 statutory options of guilty, not guilty, or nolo contendere were presented to the defendant and he chose one. He thus failed to enforce his right to be prosecuted in a court of record. Once the agreement or the arraignment, as evidenced in the arraignment proceeding, has been secured, the court proceeds under statutory authority. Now, the court ceases to be a court of record and becomes a court of no record by prior lack of objection, by prior agreement applied by the failure to object. So, what they're saying is in the time of the arraignment, that's when you object, you challenge jurisdiction. But we also know that based on all of the deceit and basically the deceit and the fraud that has been upon us, we also have cases where jurisdiction, not just in an arraignment, where jurisdiction can be challenged at any time, and we have those court cases to back that up. But this is just showing you where they are getting jurisdiction over you. Naturally, after securing the agreement, a nisi prius court can move on to examine the facts with the judge and a jury from there forward. Judge George H. Collins wrote, Mr. Thornton says that the murderers have entered into a contract to go outside of the rules of the codes, even though they don't know it. Since a contract is an agreement between two or more people, how can a contract be made without the parties knowing about it? Bill Thornton, he's going to reply, and he says, yes, if the party never objects, then he must have agreed. Surely you have heard of appeals that were lost because an objection was not timely made. The appellate court treats unopposed actions by trial courts as if those actions were agreed to by the party who untimely objected. So he's saying that they can get their jurisdiction over you if you don't object to it. George Collins also wrote, he says that the penal codes are not the law. My understanding is that the law is the statutes or codes plus the law made by appellate judges every time they make a decision. So if the penal code is not the law, what is? So this is his question, and Bill Thornton, he's going to reply. He says, when the word law is used without qualification, then it means common law. An attorney at law means one who practices common law, notwithstanding the fact that modern attorneys are not trained about the subject. An attorney in equity is one who practices before an equity court. And in the United States, 99.9% of all proceedings are in equity, which is why the judges take liberties. So most of our courts are equity courts and not common law courts. Statutes are expressions of will from the legislature. To keep you confused, they append the word law to it. Naturally, you are supposed to then believe that statutory law is the same and is equal to common law, but it isn't. Codes are nothing more than a collection of statutes and other rules arranged by subject instead of being arranged by date. Law beats statutes, and statutes beat codes. A judge exercises his discretion because he is authorized by the statutes to exercise his discretion. Most appeals of judges' decisions will fail. The appellate courts generally will not second-guess a trial court's use of discretion. So that's talking about their de facto courts right there on those. And in a court of record, so that's the discretion of the judges in the de facto. Here in a court of record, that's our common law court, a judge has no discretion. Discretion is reserved to the independent tribunal. And the independent tribunal, remember, is your jury. They are the sovereigns. They are the independent tribunal. They are the ones that have the power in the court. The other person that has the power of the court is going to be your sovereign. Whether that sovereign is a defendant or an accused or the accuser, they are also considered a tribunal as well. All right, so that finishes. Hey, there we go. We did good. That finishes what I have for tonight in training on the courts. Next week, we will be going into the law of the case, and I'll actually have a whole case put up there of how the pleadings are put together by the defendants or the not defendants, either the accused or the accuser, so that all of it is there in one file. We'll be going over that next week, and then we will start to do mock trials before our courts. Do we have any questions or discussion, anything that you've heard on courts tonight? No? Okay. If we have no questions, no comments, then this is going to end the training. Let me stop the record, and we will have another one next week.